So let's move to section 64 of BNS. Please look at the language of section 64, clause 1 in your bare axe. The provision states, whoever, except in the cases provided for subsection 2, commits rape shall be punished with rigorous imprisonment of either description for a term which shall not be less than 10 years but which may extend to imprisonment for life and shall also be liable to fine. So clause 1 of section 64 outlines a punishment for an individual who commits rape except in the specific aggravated circumstances listed in subsection 2. This clause deals with the punishment part, which we will take up later in the discussion. Let's discuss clause 2 of section 64 here. It talks about circumstances where the punishment is enhanced when the offender abuses a position of authority. So when the offender is in position of authority, trust, or committed the act in a specific vulnerable context, then the act of rape would be an aggravated act of rape. Who can be an offender in a position of authority? Enhanced punishment is attracted for the offender. So let's see who can be an offender here. Police officer, it is given in clause A of section 64. Public servant, clause B. Member of armed forces, clause C. Then in clause D, section 64, subsection clause 2, management or staff of jail or correctional facility or any other place of custody established by law. Then relative, guardian, teacher, person in position of trust or authority. One thing should be noted here that rape is an aggravated offense when the victim is under their trust or care. It is a mandatory thing. It is there in the language of section 64 subclause. So please go through the language of section 64. So these persons, when in authority, abuse their authority and commit rape against their care or protection, they would be liable for aggravated offense of rape. The focus here is on the abuse of power and authority. The law recognizes that rape committed by a person in a position of trust is far more heinous. Example, a doctor committing rape of patient or police officer committing rape of someone who is in police station. Rationale for the enhanced punishment for these offenders is that the victim in these circumstances are often less able to report or resist due to institutional or systematic pressure. Let's look at some more circumstances of aggravated offense. Vulnerability of the victim is also important, means or when is the offense committed. During communal rioting violence, during communal or sectarian violence, or when or on a woman whom the man knows to be pregnant. This is there in clause F. During communal and sectarian violence is given in clause G. On a woman incapable of giving consent, I. Clause I. Clause K says rape on a woman by person in control or dominance over that woman. Then on a woman who is physically or mentally disabled. Clause J talks about the situation where the offender while committing rape causes grievous bodily harm or maims or disfigures or endangers the life of the woman. And the clause M talks about the rape by an offender repeatedly committing the offense against the same woman. So we have covered all these circumstances, all these situations when the rape is considered an aggravated offense of rape. Please go through the language of the section. Let's see the penalties. The punishment for rape is given in section 64, subsection 1. And for aggravated offense of rape, it is there in section 64, subsection 2. Let's discuss and look at the changes from IPC to BNS. The punishment under section 64, subsection 2 for general rape is minimum 10 years, which can extend up to life imprisonment along with fine. So the rape, when not aggravated offense, the punishment is minimum 10 years, which can extend to up to life imprisonment along with fine. The key change from IPC to BNS is the elevation of the minimum punishment for general rape from 7 to 10 years. Earlier it was 7 years, now it is minimum is 10 years. So this change signals the legislative intent to treat all cases of rape with even greater severity. Let's see the punishment for aggravated offence of rape. It is there in subsection 2 of section 64. It is 10 years to life imprisonment along with fine. Life imprisonment here means imprisonment for the remainder of natural life of the convict. This is very important. Mandatory fine and compensation is there. It is there. It must be just and reasonable and must be paid to the victim for medical expenses, rehabilitation, and maintenance. In addition, the fine imposed in these sections is in addition to any other compensation under State Victim Compensation Scheme. We now move to section 65 of the BNS, which deals with the aggravated forms of rape, where the primary factor escalating the sentence is the age of the victim. This provision is a direct continuation of the policy established post 2013 to ensure robust protection for children. To trigger this section, we must first confirm the commission of rape under section 63. The aggravating factor then kicks in based on the victim's age. For a victim under 16 years of age, which is given under section 65, subclause 1, under 16 years of age, the punishment is minimum 20 years of rigorous imprisonment, which can extend for life, the offender's natural life. So the minimum punishment is 20 years, but which can extend up to life imprisonment, meaning natural life of the offender plus fine. This is a significant jump from the 10-year minimum for general rape. And let's see, if the victim is under 12 years of age, then it is a victim under 12 years of age, which is given under section 65 clause 2. Then the punishment is rigorous imprisonment for a term not less than 20 years, which may extend to imprisonment for life and with fine or death. So here the punishment is, one of the punishments could also be death penalty. Thus, this punishment is within the rarest of the rare category due to extreme culpability involved in the crime. Please note that the section explicitly provides that the fine under this section shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, and that any other fine imposed under this section shall be paid to the victim. Dear learners, please also remember that while the BNS covers this, most cases involving victims under 18 years of age are tried under the POCSO Act of 2012, which has dedicated procedures and safeguards. The Supreme Court, in cases such as Rajesh Yadav versus State of UP, has consistently upheld the legislative intent behind these enhanced punishment, absolute deterrence, and sentences that reflect the grievous harm caused to a child. Causing death or persistent vegetative state. Section 66 focuses on the consequence of sexual act, making them the defining element of the crime's severity. This is for cases where the act of rape is so brutal that it results in either of the two tragic outcomes, the death of the woman or her entering into a persistent vegetative state, either death or persistent vegetative state. What is persistent vegetative state? It is a chronic condition where an individual appears awake but lacks awareness of their surrounding due to severe brain damage. The law treats PVS as being equivalent to death in terms of sentencing gravity, and this reflects judicial awareness rooted in landmark cases like Aruna Shanbag versus Union of India. PVS, as you know, is a long-term state of severe unconsciousness. The BNS prescribes the highest penalties: imprisonment for natural life, person's natural life, or death. Why? Because PVS is treated equivalent to death in terms of sentencing severity. Please look at the table on your slides. The offence under section 66 shifts the focus from the act of rape itself to the causative link between the act and the fatal consequences. Due to the potential for the death sentence, the trial under section 66 requires the highest standard of evidence, particularly detailed medical evidence, to establish this causation. Thus, the prosecution must establish a direct causative link, that is, the injuries led to death or PVS. So, this brings us to the end of part 1 of our discussion. We will continue with part 2 That is from section 67 onwards. Thank you. Welcome back, dear learners. Let's begin with part 2 of our discussion. Let's begin with section 67. Section 67 replaces section 375B of IPC. Let's read the text of the section 67 first. Sexual intercourse by husband upon his wife during separation. Whoever has sexual intercourse with his own wife who is living separately, whether under a decree of separation or otherwise, without her consent shall be punished with imprisonment of either description for a term which shall not be less than 2 years, but which may extend to 7 years and shall also be liable to fine. In this explanation, in this section, sexual intercourse shall mean any of the acts mentioned in clauses A to D of section 63. This provision is carved out of a narrow exception to the marital rape exception found in Bharatiya Nyaya Samhita section 63. Section 67 of BNS acknowledges that consent remains essential even within marriage, especially when the spouse is living separately from the husband. It reflects a shift in India's legal framework towards respecting individual dignity and bodily autonomy regardless of the marital status. The law recognizes that once a couple has decided to live separately, so there's a couple, they have a valid marriage, they have decided to live separately, either under a court decree or otherwise. Otherwise here is included because otherwise here is included to protect the wives. The most critical ingredient, therefore, is the separation status. Notice that the definition of separation is broad. Notice that the definition of a separation is broad. It includes formal de jure separation under a court's decree, but critically, it also includes de facto separation caused by estrangement, desertion, or mutual agreement, even if they lack a formal court order. So, if the husband then forces sexual intercourse on his wife, who must be 18 or above, without her consent during this formal separation, he commits the offence. Please note the crucial distinction here. He is not charged with rape under section 63, but with a separate offence under section 67, which carries a lesser but still significant punishment of between 2 to 7 years. That is a punishment. That is, the punishment shall not be less than 2 years, but which may extend to 7 years and shall also be liable to fine. This distinction underscores the legislative intent to partially recognize wife's independence upon separation without fully abolishing the marital rape exception. Section 68. Sexual intercourse by a person in authority. Section 68 of Bharatiya Nyaya Samhita addresses situations where a person in a position of authority engages in sexual intercourse with someone under their influence or control. This provision criminalizes the abuse of power in cases where consent is obtained through misuse of authority, recognizing the coercive power dynamics that can undermine true consent. Now let's read the language of section 68. Sexual intercourse by a person in authority. If whoever being in a position of authority or in fiduciary relationship. What is fiduciary relationship? A fiduciary relationship is a legal or ethical bond where one party is obligated to act in the best interest of another party. Let's move to the clause B. It says, a public servant, a superintendent or manager of a jail, remand home or other place of custody, established by or under any law for the time being in force, or a women's or children's institution, on the management of a hospital or being the staff of a hospital. So, whoever abuses such power or fiduciary relationship to induce or seduce any woman either in his custody or or under his charge or present in the premise to have sexual intercourse, such sexual intercourse not amounting to the offence of rape shall be punished. It does not amount to the offence of rape, but it is an offence and it is punishable. Such person shall be punished with rigorous imprisonment of either description for a term which shall not be less than 5 years, but which may extend to 10 years and shall also be liable to fine. So 5 to 10 years of punishment will be given along with fine. Section 68 targets the abuse of official power or position to coerce sexual relations. This isn't purely about physical force, it is also about overwhelming power dynamics that compromises the victim's consent. This law covers persons in position of trust or control, such as superintendents, managers, doctors, or educators, particularly those in institutions like hospitals, jails, or educational facilities. The core of the crime is that the accused induces or seduces the woman who is under his charge to submit. The law deems any consent obtained in the environment, in this environment, as meaningless because it is essentially vitiated due to the duress, inducement, or fear arising from the accused authority. So, the law considers that if any consent is obtained here, it is already vitiated because it is based on duress, that is, threat, inducement, or fear related to the authority. Let's take an example. A doctor having sexual intercourse with a patient, even if she verbally agrees, is exploiting the fiduciary relationship and the patient's inherent vulnerability. Doctor would be liable under this section. The punishment is rigorous. It is an imprisonment from 5 to 10 years, reflecting the serious breach of. The punishment is rigorous imprisonment from 5 to 10 years. Why this is rigorous imprisonment? Because it breaches the trust of public. Please have a look at this slide to understand the offense of Section 68 more clearly. Section 69, sexual intercourse by employing deceitful means. Let's read the section first. Whoever by deceitful means or by making promise to marry a woman without any intention of fulfilling the same has sexual intercourse with her, such sexual intercourse not amounting to offence of rape shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Explanation: deceitful means shall include inducement for or false promise of employment, promotion, or marrying by suppressing identity. Section 69 is a new dedicated section in the Act. This provision formally codifies decades of judicial interpretation regarding consent vitiated by deceitful means. It addresses sexual intercourse that does not technically meet the definition of rape under Section 63, but where consent is secured through fraud or misrepresentation. The law is focused on situations including false promise to marry, where the man had no intention of fulfilling the promise at the time it was made. That is, since the beginning, there was no intention to marry. This is what we call ab initio fraud from the beginning. It also covers using false promises of employment or promotion or suppression of identity, like concealing marital status, caste, to induce belief in a relationship that does not exist. The essence is that women's consent is based on fundamental misconception of fact created by the accused's deception. The penalty for this specific crime is imprisonment up to 10 years and fine. The primary legal hurdle, which we will discuss next, is proving that the intention was fraudulent from the very outset, from the very beginning. Please go through the slide carefully. As you can see, the application of Section 69 hinges entirely on the mental element mens rea of the accused at the time the promise was made. To successfully prosecute a case under Section 69, the court must carefully differentiate between a false promise and a simple breach of promise. As our table illustrates, the difference hinges entirely on the mens rea, or the mental element of the accused at the time the promise was made. If a man genuinely intended to marry at the time of the sexual act, but later, due to the change of heart or unforeseen circumstances, breaks the promise, that is breach of promise and not an offense under this section, as relationship was initially consensual. However, if the promise was dishonest from the very start, as highlighted in the case like Pramod Surya, as highlighted in the cases like Pramod Surya Bhan Power versus State of Maharashtra, then it is a criminal offense. The prosecution's evidence in these cases, therefore, must focus heavily on revealing the man's dishonest intent, perhaps through evidences of concealed facts, a pattern of fraudulent behavior, or the immediate abandonment of the relationship after the objective was achieved. Section 70, gang rape. Section 70 provides that where a woman is raped by one or more persons constituting a group or acting in furtherance of a common intention, each of those persons shall be deemed to have committed the offence of rape. There are two clauses in this section based on the age of the victim or survivor: 18 years or above, under 18. For gang rape of a person of 18 years and above, the punishment is minimum of 20 years, which may extend up to natural life of the person along with fine. This is already a higher punishment than genuine rape. So let's see where the victim is a minor under 18 years of age. This is given under section 70, subsection 2, aggravated gang rape. The punishment is escalated to life imprisonment for natural life or the death penalty along with fine. The section's severity reflects India's stringent approach to the group sexual violence, ensuring those involved in this kind of brutality face the highest possible legal action regardless of their specific role in the act. One important thing to note is regarding the fine under this section. BNS section 70 clearly stipulates that such a fine shall be just and reasonable to meet the medical expenses and rehabilitation of the victim, and that any fine imposed under this subsection shall be paid to the victim. This was also provided under section 65 as well. This was provided under section 65 as well. Section 71, punishment for repeat offenders. This is a critical deterrent law focusing squarely on recidivism, that is, the tendency of a convicted criminal to re-offend. The law sends an unequivocal message of zero tolerance for habitual sexual offenders. If an individual has been previously convicted of any of the most severe rape offences under section 64, 65, 66 or 70 and is subsequently convicted of any of those same offences, the most severe penalty is mandatory. The court is required to impose imprisonment for the remainder of person's natural life or the death penalty. The procedural mechanism dictates The procedural mechanics dictate that the trial first proves the subsequent offence and then the evidence of prior conviction is brought in. This provision is essentially aimed at protecting society from individuals who demonstrate a persistent and a dangerous habit for grave sexual violence, justifying the most differential and harshest punishment under the Act. Section 72. Section 72 is a vital safeguard for victim protection. Please look at the table on your slide. It strictly prohibits the disclosure of identity of the victim. This extends to printing, publishing any matter related to the court's proceeding. It includes photograph, name, etc. The purpose is clear: to shield the victim from social stigma, humiliation, and secondary victimization, upholding her right to dignity under Article 21. Remember, disclosure is only permitted when the written authorization of the victim's next of kin or by a direct order of the court is there, as it was laid down in Nipun Saxena versus Union of India guidelines. The punishment for this is imprisonment up to 2 years, along with, let's see at the BNS specific amendments and changes. The Bharatiya Nyaya Sanhita, let's see the BNS, let's see the specific amendments and changes in BNS. The Bharatiya Nyaya Sanhita retains the core principle of IPC but introduces critical adjustments. First, marital age raised under section 63, exception 2. It explicitly raises the minimum age of wife for the marital rape exception from 15 to 18 years. This codifies the independent thought Supreme Court ruling. This is a very important case. Please go through this case. Then, second, the minimum sentence increased under Section 64. The general minimum sentence for rape earlier was 7 years. It is now 10 years. There is definition continuity. There is no major definitional change. The expanded gender-specific definition of penetration and the 7 vitiating circumstances from the 2013 IPC are retained without any major definitional change. The marital rape exception status remains the same for wives the marital rape exception status remains the same for wives aged 18 or above. Section 69 was added in BNS in 2013. We've covered all these points. So let's move to, let's look at the procedural protection for the victims. The procedure is given under BNSS. There's a provision for mandatory medical exam under Section 184 of BNSS, which corresponds to Section 164A of CRPC. It mandates medical examination of the victim and the accused, both the victim and the accused. The procedure for recording the evidence is under Section 183 of BNSS, which corresponds to Section 167 of CRPC. And as per this section, the victim's statement must be recorded by a judicial magistrate. Maintaining the victim's privacy is very important. It is there in Section 366, subclause 2 of BNSS, and it mandates in-camera trial, which should not be in open court. It should not be in an open court. In-camera trial is important for the victim to testify freely without the fear of and pressure of public setting. It also prohibits printing or publishing the victim's name or identifying details. This is absolute. Publishing the victim's name, even with her permission, can lead to criminal prosecution. The media and the public must strictly adhere to using other names, aliases, such as Nirbhaya, X, A, Y, Z, etc. The provision for legal aid is given under Section 341 BNSS. The victim is entitled to free legal aid or services. These procedural safeguards ensure that the process of seeking justice does not further victimize the survivor. Societal and constitutional implications. The offence of rape is not merely a crime against an individual, but a fundamental breach of constitutional right also. There's a violation of constitutional rights. Rape is a profound violation of victims' fundamental rights, right to life and liberty under Article 21. It includes right to dignity, bodily integrity, and autonomy. Gender equality points should also be noted. The offence directly addresses systematic gender inequality and violence against women. Under Article 14, Equality Before Law, this is linked to Article 14. Let's talk about social stigma. The courts have a mandate to address the deep-rooted social stigma that often impedes the justice process, leading to victims retracting statement or delaying justice. So it should also be addressed. One of the most important things is autonomy. The law champions the principle of bodily autonomy. This is very, very important. A woman's decision over her body is paramount and cannot be negated by social pressure or archaic notions of honor. So this brings us to conclusion. We have covered almost everything that is important to understand rape, to understand the offense of rape. So let's recap. The definition is expansive. Under BNS Section 63, rape now covers 4 types of penetration, not limited to penile vaginal penetration. Then the consent is the key. In explanation 2 of Section 63, consent is legally defined as unequivocal, voluntary, and specific. BNS is harsher. BNS increases the general minimum sentence of punishment from 7 to 10 years. We've already discussed this, and it has also raised the marital rape exception age from 15 to 18 years. Judicial mandate: courts must apply the presumption of lack of consent and rigorously exclude character evidence. This is also very important. Presumption of lack of consent, section which was earlier dealt with in Section 114A of Indian Evidence Act. One thing should be noted that there's a remaining challenge, the marital rape exception for wives who are 18 or 18 plus, and it remains the final frontier of reform. This continued to be debated and challenged in India's highest courts. So that's all for this topic. Thank you.